Добрый день.
Dear ladies and gentlemen, dear colleagues, we are starting our Dissertation Council session. For the defense of dissertation, Makarov, Vladislav Olegovich for legal field, the theory of law and state. And the topic is the transformation of legal procedure under the influence of the internet. According to the decision of the rector of St. Petersburg University, this dissertation council was formed, and I, Polikov Andrei Vasilyevich, Doctor of Legal Sciences, a professor of the Department of Theory and History of State and Law, St. Petersburg State University, was appointed chairman of this dissertation council. I would like to introduce now my colleagues, members of the dissertation council. Shevilova Natalia Alexandrovna, Doctor of Legal Sciences, Professor, Head of Department of Administrative Financial Law, St. Petersburg State University. Yelena Anatolyevna Voynikakin, Doctor of Legal Sciences, National Research University, High School of Economics. Romashov Roman Anatolovich, Doctor of Legal Science, St. Petersburg University of the Humanity of Trade Unions. And also on Skype with us, Grigory Alexeyevich Vasilievich, Doctor of Legal Sciences, Belarus State University, the Republic of Belarus. He is head of the Department of Law. So this is our international colleague. Although Grigory Alexandrovich, can you hear us? Yes, I can hear you very well. Great. So, to start with, I would like to note that in accordance with the federal law dated 23rd August 1996 on science and state scientific technical policy, St. Petersburg State University received the right to issue degrees, academic degrees, independently, and an act on the procedure of awarding academic degrees of St. Petersburg University was adopted on the 1st of September 2016. In accordance with this act, the session of the Dissertation Council is legitimate if no less than 2/3 of the established membership of the Dissertation Council are present, but not fewer than 4 members. Our Dissertation Council consists of 5 members. Everybody is here. All the present, and the defendant is at the podium, and so the quorum is there. Just a few words on the procedure. First of all, I would present the documentation that the defendant submitted, and then there's a short presentation of the defendant seeking the academic degree for 15 minutes on the core of his dissertation, and the questions to the defendant covering the presentation, not more than 2 minutes per question, and then answers of the defendant. Then I would like to read, I need to read all the external reviews. All the reviews have been uploaded to the university website, so therefore I will just read out the critical parts. And then members of the Dissertation Council will take turns to read their reviews with questions and comments to the defendant. And then I would present my review, then answers, after that answers of the defendant will follow, and again the limit is under 15 minutes. Later we will have time for open discussion from the floor. Anyone willing to speak up? Are there any people who would like to speak up? If you want to speak up, you have to enter your name into the registration book. And then item number 1 on the agenda is the concluding remarks of the defendant, not more than 5 minutes. Then the academic supervisor will speak and give his comments for 3 minutes. Then there will be a discussion period when the broadcast will be switched off, where we'll discuss our verdict to grant or not to grant this degree. And then after that, the broadcast will be switched on, and there will be voting, open voting, and the chairman will count the votes, and then the decision will be taken, and concluding word of the defendant, not more than 2 minutes. So I would like to ask our colleagues to switch off their mobile phones, because this will interfere with our broadcast, because there's an audio and video recording of this session, and there's a live broadcast of this session on the university website, and the simultaneous interpretation is provided. The simultaneous interpreter is in the booth. So the first item is my short presentation on the documentation that I present. First of all, the defendant submitted an application addressed to the rector of St. Petersburg University, Nikolai Mikhailovich Kropchev, dated on the 7th of September 2018. There's a review of the scientific academic advisor of the defendant, Marina Leonidovna Davidova, Doctor of Legal Sciences, Head of the Department of Constitutional and Municipal Law of Volgograd State University. There's a statement recommending the dissertation for the defense that was issued on the 10th of July 2018 by the senior vice rector of Vologda State University, Professor Kalinina. There's the list of publications consists of 24 items in which core results of dissertations are covered. They're not indexed in international databases, but there are 5 articles that are published in the journals that are placed on the list of Minister of Education, the Russian Federation, so the minimum requirement is met. There's a diploma, cum laude diploma, dated 30th June 2014 of Vologda State University, which states that Makarov Vladislav Olegovich was awarded the qualification of jurist in the field jurisprudence. And then there's a certificate on doctoral studies issued by Vologda State University, which states that from the 1st December 2014 to 31st of August 2017, he passed the following candidate exams: theory of history of law and state, history of law and state. The mark is excellent, English excellent, history and philosophy of science excellent. There's a diploma on doctoral sciences, a doctoral study completion, and then dissertation in hard copy and soft copy is also submitted. Everything complies with all the requirements. All the documents comply with the requirements of St. Petersburg University on awarding the degrees of Candidate of Sciences. Do you have any questions? No questions. Well, then I would like to give the floor to the defendant, who will talk about his dissertation. Dear Chairman, dear members of the Dissertation Council, dear members of the audience, the dissertation research presented to you is devoted to the transformation of legal procedures under the influence of the Internet. Today, information and communication technologies have become a significant factor affecting the functioning of society, creating new and transforming already established social institutions. By creating new specific social relations that arise in cyberspace, the Internet transforms the hierarchical principle of administration and control, changing traditional mechanisms. The legal vacuum in cyberspace has become filled with various initiatives on the legal regulation of the Internet, both at the national and international levels. Thus, the emergence of a number of legislative sources regulating relations on the Internet has led to the emergence of a separate sphere of knowledge, which consists in the relationship of law and the specific object to which it is applied, the Internet. In addition, the technologies themselves have had and continue to have a significant impact on the function of the state and law, transforming them. At the same time, there's a mutual influence, both the right to the development and the regulation of the information and the communication sphere and the technologies on the function of law and the state. At the same time, the impact of the Internet on the legal system is complex, allowing one to speak not so much about individual changes as about the transformation of the entire system as a whole. In any case, the results of this impact are found when considering each structural element of the legal system. The above determines the relevance of the chosen topic. Today, the study of the impact of the law and the Internet, as well as this legal regulation, is being conducted to a quite significant extent, and in the dissertation research, an attempt was made to investigate the reverse process, the impact of the Internet on the law, by studying the transformation of legal procedures as one of the important structural elements of the legal system. At the same time, the stated topic of the thesis was not previously the subject of a full-fledged study. There are no specialized monographs on the selected scientific problem in modern Russian legal science. In this regard, the academic novelty of the dissertation work is that the author made a comprehensive study of the impact of the Internet and information and communication technologies on legal procedures. Based on the study of both theoretical positions and empirical industry material, the following conclusions were obtained. So we formulate the following definition of concept under study. A legal procedure is a hierarchically constructed, service-oriented, and dynamically formally defined and normatively and individually established set consistently carried out legally significant actions aimed at achieving a single legal result related to the exercise of rights and obligations by participants in public relations, and one of that develops according to the specific model. Signs of a legal procedure include focus on achieving a legal result, sequence of successive acts of behavior, the presence of a model or program of its development, hierarchy, dynamism, service character, formal certainty, and the presence of a set of norms in a space. This list is not only of theoretical significance. The presence of these signs in the studied phenomena allows us to distinguish precisely legal procedures without going beyond the scope of the subject object of study and the problem field. As a result, within the framework of the work, empirical material is checked for compliance with the object of study. At the same time, the legal procedure performs the following functions: protection of the rights of freedoms of participants in legal relations, prediction of the legal result, prevention of violation of the regime of legality, the establishment of a template model of actions like algorithm in typical legal situations. 5. Increase of the effectiveness of legal regulation. We also studied the positions of legal science on the relationship between the categories legal procedure and legal process. As a result, according to the author, such a relationship must be made on the basis of two criteria in terms of scope and degree of complexity. The degree of complexity of the legal process acts as a broader phenomenon because in the structure, legal procedure is part. Is only part. The latter act as its elements, dynamic and functional parts of the process. However, the scope of the legal procedure is broader than the legal process, since the procedures exist not only as components of the legal process. Examples include powerless civil procedures, for example, the conclusion, amendment, or termination contracts. The solution of this problem allowed us to single out the legal procedures proper without confusing further study of legal procedures and relevant empirical material with phenomena related to the legal process. After analyzing the points of view available in science and the literature, the author proposes a classification of legal procedures. So it seems possible to make their division into procedural and non-procedural. Due to the fact that the legal process, the result, the legal procedures that constituted are not limited solely to the activities of the judicial authorities, judicial and non-judicial procedures can be distinguished from the procedural legal procedures. The classification of judicial legal procedures is based on the identification of existing types of judicial process. These include constitutional procedural, civil procedurals, criminal procedural, arbitration procedures, as well as procedures constituting administrative proceedings. In addition, there are also non-judicial processes, in connection with which, among non-judicial legal procedures, the author distinguishes lawmaking, administrative, budgetary, and electoral ones. Each of the presented types is based on a separate type of legal process, which, while not being a judicial, nonetheless exists as a separate procedural legal activity. Non-procedural legal procedure, in turn, can be domineering and powerless. This classification allowed for the further structuring and systemization of empirical material. The study also identified 3 areas of legal procedure transformation influenced by the Internet. The emergence of new legal procedures, the change of existing legal procedure, and the termination of the existence of legal procedures in the traditional form under the influence of the Internet. The study of legal procedures allowed us to identify trends in their development. These include the development of the principles of openness and the publicity of the judicial process, reducing the burden of on the staff of the courts and the participants in the legal proceedings, changing the financial burden on the judiciary, algorithmization of the trial, increasing the availability of justice, increasing the role of technical standards. As a result of the study of non-judicial legal procedures under the influence of the Internet, the following development trends were identified, such as increasing the openness of transparency of information of legal significance. Strengthening control over information on the Internet, duplication of information sharing, the increasing role of technical standards, increasing the volume of subordinate regulatory legal acts. In turn, the trends in the transformation of non-procedural legal procedures under the influence of the Internet are a systematization of information of legal significance, the use of self-regulation as an important non-procedural method of regulation of the Internet. On the Internet, a simplification of interaction between the state and citizens, about the exchange of information, the receipt of public services, electronic transfer of individual procedures, security of legal procedures by technical means. As a result of a study of sectoral legal procedures and on the basis of selected trends, the following conclusions can be drawn. First, the change in the form of judicial procedures, legal procedures, influences their content, transforming it, as a result of which the degree of algorithmization of the judicial process increases. Procedural legislation contains forms that exclude oral proceedings, for example, summary proceedings in the arbitration process. As a result of which, in parallel, there are two forms of proceedings: traditional with personal oral participation of the parties, and electronic without calling the parties to be present. If this trend is strengthened, we should expect an increase in the share of the latter, for example, for disputes based on common circumstances and typical legal grounds. The procedure for creating a draft judicial act in such cases may be automated, but it will still require the personal participation of the judge to access the specific circumstances. Secondly, the implementation of electronic legal procedures, which have a comprehensive regulatory nature, is largely ensured by the technical status that perform a supporting function, in contrast to traditional legal procedures, which are governed exclusively by legal norms. In connection with the increasing role of technical norms, there is an increase in sub-legal regulatory array, which contains detailed requirements and algorithms that specify electronic procedures established by federal legislation. Thirdly, due to the architecture of the Internet and the specifics of the electronic space, there are certain areas where there is no need for state law intervention, and legal regulatory methods may not always work effectively. The means of controlling and influencing users in such cases are expressed in the form of micro-level self-regulation procedures, website rules, user agreements, etc. There is also a higher level of self-regulation, the creation of international and national organizations. We believe that the specificity of the norms of self-regulation is similar to the legal nature of local regulatory legal acts. Fourth, the state duplicates some of its procedures, introducing an electronic form while maintaining the traditional previously existing forms. As a result, in parallel, there are both options. New emerging procedures related to the Internet most often already operate exclusively in the electronic form without their integration into the system on paper. However, there are a number of procedures that have lost their traditional form, continuing to exist only in the form of electronic procedures. Note that the main participants in such procedures is a professional business entity. This is due to the higher requirements imposed on the state, on legal entities and individual entrepreneurs. Such entities have a greater range of technical capabilities. Fifth, the architecture of the Internet affects the development of procedures law, resulting in quantitative increase in procedures. We believe that the main conclusions of this dissertation are within the framework of the subject declared for it and introduce certain elements of novelty into the domestic legal doctrine. Thank you very much for attention. Do you have any questions for the presenter? Any questions? Please. Roman Anatolyevich? Vladislav Olegovich, could you tell me that any innovation that implies that traditional elements are necessary. But you never explained why innovating methods should be introduced if the existing methods can meet all the goals. Thank you very much for your question. The qualification of legal procedure by putting them into a powerless and powerful procedures. I wanted to combine all the legal procedures, all the types of legal procedures into one group and one classification. And the second goal that I put in front of me is structuring the empirical material for the study through structural method for the purposes of this work. And I think that this allowed us to create a structure of electronic procedures that are caused by the internet, and study them in detail. Thank you. Any other questions? Andrei Vladislav, I have a question, just one question. Yes, Grigor. Vladislav Olegovich, I liked your definition of legal procedure as a set of successful actions and all other components. What do you mean that legal procedure has a model of for its development? What do you mean by the program or model of the development? Yes, please. Thank you very much for your question. I would like to clarify that we identify as a model of the legal procedure as an indispensable property of legal procedure. This is a legal prognosis or forecasting, because procedure is aimed at achieving a specific legal result for the protection of participants of the legal proceedings, and therefore the legal procedure always has a program of its development, and therefore the procedure according to this program so that the procedure could achieve its result by following this program. This is an inherent capacity, inherent function of legal procedure. If you have any questions, the next item on the agenda. External reviews. We have an external review by Maximov Sergei Ivanovich, member of the National Academy of Legal Sciences of Ukraine, professor of National Legal University named after Yaroslav Mudry, Yaroslav the Wise, and this is a very positive review. I will just read out the critical parts. There are two of them, two critical points. There needs to be additional clarification of the selection criteria. There are some legal procedures that are under the effect of the internet, but how do you define which procedures can be ignored and which procedures can be or were ignored in the work, and others were taken for study. And the second one is a tendency is increasing the normative body. This is caused by the internet. How can the internet actually cause the increase in the body of normative acts? But the overall conclusion of the review is that the dissertation complies with all the requirements, and Sergei Ivanovich supports the decision to grant the sought degree to the defendant. So you can answer these questions when you answer the questions of all the other reviews. So now we'll turn to the next review. Review by member of the Dissertation Council. Natalia Alexandrovna will read out her review. Dear colleagues, I would like to say that the dissertation has appealed to me, and so the amount of work that was done by the dissertation author is impressive. All the arguments that the dissertation topic is very relevant. It's really true. The topic is more than relevant. And for example, our regional phenomenon is the electronic card of the citizen of St. Petersburg. It's one example of it, and there's a draft law, the electronic profile of a citizen, that will be discussed by the State Duma, and this is exactly what the dissertation author has studied. And what's more important, that the theoretical approach that Mr. Makarov took is very productive, because the relation between the citizen organization and the public state body through the internet, for example, the immigration service, for example, and the taxation service, is this relationship is very good subject to study. And when you create a uniform approach to the study of all these new phenomena, this really contributes to the legal field. Theoretical importance is also evident in the fact that 17 procedures have been selected, identified by the author, and studied in detail. And the selection of this list covers most and at the same time diverse procedures that belong to different fields. And so the study has a comprehensive nature, and this list of these procedures cover procedures of different nature. In one, there's a right of the citizens to demand of state bodies information, and in others, other rights are focused on. And so the author in this case unfortunately lacks the dissertation lacks a unifying principle that delineate these procedures and at the same time puts them on one scale, and the author approaches the research questions very creatively, which is very laudable. And the next thing I want to focus on by giving definition to legal procedure. The author presents his own definition, and in this definition there is no connection to information technologies, so there's an open question. The author distinguishes between the procedures that involve the information technologies and the ones that you know, if he is indiscriminate in this regard, why how does he relate this definition to the actual title of the dissertation and the research area? This is my big question. And some procedures that are identified make me be doubtful that these procedures can be actually called procedures, legal procedures. For example, some requests for information that are obtained on the portal, government portal, that have to do with budgetary relations, and the citizens as consumers of this information, but the lawmaker has not specified any legal procedures in relation to obtaining this information. The next point is classification is there of the legal procedure. The judicial, non-judicial, court, out of the court procedures, but the system of the grounds for classification are not transparent. For example, our procedure here that we're engaged in now, what kind of procedure is this? According to your classification, I have some idea, but I'm not sure whether your classification explains automatically how I should put where I should put it. When you specify functions and signs of the procedure that are applied to any category of procedure, the results of the results follow from this deliberations, and I agree with the author in most conclusions, and I think that the arguments are valid, and so the author presents some positive results. And so, therefore, on the basis of what I've said, I can state that the dissertation complies fully with the requirements of this university on the conferring of the degree of candidate of sciences. Roman Anatolyevich, please, your turn. Could you please read out your review? Dear colleagues, since Natalia Alexandrovna gave a very detailed analysis of the structure and main conclusions of the dissertations, I think that the work is relevant for contemporary Russia with procedural in the field of procedural law. The conclusions are very important, especially in relation to the humanization of the legal field. In the procedural field, we have a reverse trend, and then there's a very relevant field of the internet application of applying the internet technologies into legal procedures. So this field requires academic study. The work is logically structured. The provisions are argued and well argued, and the statements have been published and discussed by in different articles, but there are some critical points that I have for the defender. There's a disproportionate imbalance between the legal and the technical parts of the work. The first part totally conforms with the requirements of the legal field for which in which the dissertation is written. But the second part of the dissertation is more of a technical nature, and unfortunately the theoretical nature is lost. The first part is very theoretical, and the second part is more information technology applied part. But the academic relevance is there. But unfortunately, in the extended resume published by the author, I don't see any novelty. There's no information about the new innovative conclusions of the author. Well, main statements contradict each other, and so for example, the legal procedure is wider of the legal process, and at the same time, in the next sentence, the legal procedure is part of the legal process. So there's a contradiction there. Well, there's a repetition of legal procedure, the definitions, etc. And the methodology is very repetitive. As far as the electronic governance, so the state is first of all the electronic governance is conflated with government. The law there is electronic governance law, and Unfortunately, there's a confusion there between different terms that relate to electronic participation and relations in the electronic sphere. But nevertheless, on balance, I support the decision, the resolution of the Dissertation Council to confer the degree of Candidate of Sciences in Law to Makarov Vladislav Olegovich. Thank you very much. The next turn is Yelena Antonovna. Please read your review. I would like to note that Russian legal science studies the regulation of the internet, and there are a lot of studies, but the issues of how the internet changes the law in Russia is understudied. And therefore, this makes this work relevant. Well, at first sight, the research question is a narrow one, but the content of the research reveals an in-depth study. The author analyzes the degree of the legal algorithm changes under the influence of electronic algorithms. This is a very valuable positing of the research question in the digitalization era. So law and technology are independent, and that's what is usually believed, but I think that this is not true, because people believe that application of technology, information technology in law is just a new intervention, but and it's applied, but I think it profoundly changes the legal sphere, and therefore so it's not possible to reveal the nature of this interdependence of the internet and the legal sphere by just using the theory of law. It's not possible, and therefore I disagree with Roman Anatolovich. I think that this is a very systemically logical work, and I think that the system of legal procedure is one, and it's very much related to the changes of the legal sphere in the digitalization era. So all the procedures, every procedure is examined through the prism of the transformations under the influence of the internet. I totally agree with the definition, the author's definition of legal procedure, and I think this is a very comprehensive classification. And I also specify in my review a research contribution, scientific contribution of the dissertation authors. The review is uploaded to the university website. You can get access to it, and therefore I'm not going to dwell on the characteristics of the work, and I will turn to some controversial elements of the dissertation that are worthy of our discussion. The procedure of self-regulation is not legal, and but carries an associate function. So what is the nature of these procedures? And on the other hand, the author says that the theoretical basis of self-regulation of the Internet can be based on Lawrence Lessig concepts. But it says that that the programming code and the legal code, the Lessig says that in real space, it is regulated by legal acts, and we understand it. But in the virtual space, in the cyberspace, also some programming codes, some technical codes regulate this space. So these digital algorithms are applied. So how can we look at Facebook? If we look at Facebook, Facebook actually provides surveillance of the users and their activity, but it asks their consent for this surveillance, and therefore they do that because they want to comply with legal norms that regulate this activity, this relationship. And the second, legal and technical norms, how they interact. So the author says that legal norms and IT norms can be applied together. So are the procedures self-regulatory procedures at the micro level? How can they relate or compared with legal norms? How do they interact? So, well, the author states that the legal system is very adaptive, very resilient, and very flexible. I agree with him, but are there any risks that are associated with the electronic form of applying legal rights? For example, filtering information on the internet. For example, extra power or extra government procedures. The next thing is the influence of the internet on the procedure of concluding contracts and agreements. I agree with the most points, but this overlaps with the section of where the author describes and examines the relationship between this individual and the government in e-governance, in the e-governance sphere. So, how do you delineate these two spheres? My questions are for discussion. They don't diminish the significance of the work, and as a result, I have reached the conclusion that I endorse the work of Makarov, Vladislav Olegovich, and I believe that the defendant is entitled to be awarded the degree of Candidate of Sciences in Legal Theory of St. Petersburg University. Thank you very much. Thank you, Elena Anatolievna. And therefore, so I would like to ask Professor Vasilevich to read your review. Dear Andrei Vasilyevich, dear colleagues, for letting me take part in the Dissertation Council session. For me, it was very important to listen to my colleagues in the Dissertation Council, and I now see that the legal science in Russia is developing very dynamically. I would like to uphold the thesis that this work is very relevant. 2 or 3 decades ago, the internet started entering the legal sphere. Now we talk about the artificial intellect, and this will be reflected in legal acts. And the prognosis of regulatory framework is all very important. ICTs are a part of our life, and we are part of this sphere. So we have to approach now we turn to the point that we reach the point when an individual doesn't have to fill out documentation to request a service, but the state already has all the data. So Vladislav Olegovich took up this research area to analyze the technical side of the legal interaction, and I think this will be useful so therefore the contribution to legal theory is evident. Cyberspace initiatives there are initiatives to regulate the cyberspace and not only at the national Russian level but international level as well. This is undoubtedly a very complicated issue, and it demands resolution. The work is logically structured, the content is balanced and thought out. I think it's rounded work, research work, and all the statements that are defended have economic and social significance. This is not just dry academic statements, but have an applicable nature. And the analysis of a legal procedure, the content, and the parameters are identified. But I had a question when I read the extended resume of your dissertation. Maybe we should have talked about the parameters of these procedures, but the principles of these procedures. I think that I think the first part, the theoretical part, is a bit heavy, but in jurisprudence you have to try to present an encompassing study of material, so that's what is done in this work. I think that legal procedure is described and presented as the basis for many legal phenomena, and the classification is quite substantiated and substantive, and it presents a full idea of the research area. So maybe understudied is the influence of the internet, not only on the legal procedure, but on the whole legal field. For example, transformation. The topic of the internet transforming the legal court proceedings and the judicial procedures there, and the author also studies contractual relationships, how they start, how they get terminated, and for me it's very important. Again, the text of appeal and in Belarus are published by courts, and this information about appeals is very important for the consumers, for all the participants of the legal process. And this relates to the right to impartial court proceedings and competition. The transformation of extra court procedures under the influence of the internet, this area is very important as well. I think the conclusions are valid for the most part. Maybe in the content, well, the conclusion, of course, unfortunately, doesn't have all the statements that have been argued, but they can be the basis for further research, for further development of legal theory, and the improvements to the legislation. So the internet, unfortunately, I find it quite controversial when the author says that the internet complicates legal procedure and increases the body of or incentivizes the legal field to increase the number of legal acts, but if we talk about the artificial intellect, this is of course viable. So in conclusion, I would like to state that the dissertation fully complies with the requirements of St. Petersburg University on the conferral of the academic degrees of candidate of legal sciences, theory and history of law and state. Thank you. Thank you, Professor. And it's up to me to read my review, The task is easier for me now because after all these detailed analytical reviews, surveys of the dissertation, I have the urge and possibility to cut my review short and focus only on the critical points, so that the author could clarify some points. My overall conclusion about the station is very positive. I have no doubt that this station is very relevant, as my colleagues have stated. And this session, in these new conditions, is testament to the fact that legal procedure is being transformed. And as far as the things that need discussion, legal procedure, according to the author, consists of a set of rules, and is a certain phenomenon. Legal procedure can be set by a civil contractual code, and this statement is quite persuasive, but I would like to ask the author, what notion of law do you mean here, or do you draw your conclusion on? I would like, where's the boundary between law and other social norms and regulations? What is the boundary between legal procedure and non-legal procedure? Then again, legal process and legal procedure, how are they compared? The author reviews different positions in the literature, and the author comes to the conclusion that we should base our delineation on the degree of complexity and the width of application. So the legal procedure are part of the legal process, dynamic parts, but in the sphere of application, the legal procedure is wider than the legal process. So therefore, the legal procedure is not only part of the legal process, but can be... so this is the main idea of the dissertation. Maybe the width or the scope of the concepts. So the more complex phenomena cannot be automatically the more complex phenomena cannot be wider by necessity or narrower. They are not related. So this is a controversial point. That we talked about it already today, but maybe the dissertation is too categorical. The procedure of broadcasting judicial court hearings, well, that's the emergence of the internet actually caused the live broadcast. No, it's not true, because even before court hearings were televised or broadcast live on radio. So the next point is legal procedure is a set of forms of legal behavior. So the author himself says that procedure is a system of actions, and legal procedure is a set of successive legally significant acts. So legal norms are the conclusion, legal parts are a basis, not part of this phenomenon. Is there any reproach that would clarify this confusion? I would like to also draw your attention to the fact that procedure is a system of actions, and only then legal interactions or relationships. When legal procedure is defined in the next page, it ties with legal relationships. So procedure. So can procedural actions be part of legal procedural norm, procedural relationships, but not be part of legal norms? So as far as the second part, whether the second chapter actually is within the limits of our field, I think it is, and so therefore, and again, in terms of academic novelty and originality, what testifies to that is the original classification of legal procedure, definition of legal procedure, and the main thing is the critical analysis of legal procedure transformation under the influence of the internet, and presenting a forecast of the development of this legal phenomenon. So I have no doubt that the theoretical that the author has a command of the theoretical literature, although his survey has some drawbacks. But on balance, I would like to state that the dissertation complies with the requirements of St. Petersburg University on the conferral of the degree of candidate of legal sciences. And this is the end of my review, but the session is not over yet. Now I would like to turn to the defendant, give the defendant the right to answer Dear Chairman of the Dissertation Council, members of the Dissertation Council, first of all, I would like to thank you for the time you spent on a careful study of my work, as well as the relevant criticism and the questions in the reviews. Further answers to the questions and comments are grouped, ranging from the general to and the theoretical to the particular and debatable aspects. To begin with, I would like to respond to the comment of Professor Romashov Roman Anatolovich about the academic research novelty and the compliance of the work with the passport of the speciality. As Elena Anatolovna Voynikanis rightly noted, the interaction between law and technology would be extremely difficult to reveal, relying solely on the science of the theory of law, legal science. We believe that to study the selected process requires the study of a variety of empirical material relating to various branches of law. At the same time, the research is based on the theoretical developments. They identifying a list of features that empirical material must comply with for this consideration is a legal procedure. The creation of the author's classification of legal procedures on the basis of which there's a distinction between types of procedures that are influenced by information and communication technologies are presented by the study. However, I agree with the wording of the introduction, which reveals the academic novelty of the research is not informative. Meanwhile, we'll clarify that within the framework of the dissertation, the author's approach has been proposed to the definition of the concept of legal procedure, as well as to the relationship between the categories of legal procedure and legal process. So, additionally, we point out that the noted repetitions of the science of the legal procedures acted as a forced methodological message to substantiate the reference to the selected practice material to the object of study. Turning to the questions relating to the theoretical part of the study, an explanation should be given regarding to the question of Professor Polikov and Andrei Vasilyevich about the concept of law, which underlies the allocation of private law procedures. Our understanding of legal procedure is established not only by legal norms, but also by individual legal acts, is based on the selection in the theory of law of the so-called initiative procedures. This construction is contained in the works of Nikolai Vasilyevich Vitruk, as well as in the monograph published in 1979 devoted to the legal procedural form, edited by Petr Yemlyanovich Nedbailo and Viktor Mikhailovich Gorshinev. From this, it follows that it is fully combined with the normative concept of law. Professor Shevilova and Natalia Alexandrova draw attention to the lack of connection between the author's definition of a legal procedure and the information technology. Let me clarify that the author did not have the goal of associating the category of legal procedure with technology. On the contrary, the purely theoretical definition of the notion of legal procedure by virtue of its universality seems to us more valuable, including for further study both of the issues of technology and law and communication with other sectoral issues. The study of the influence of the Internet on law through the prism of procedures was chosen as the hypothesis level as promising since the procedure is a frequent and common manifestation of law as such. Professor Polikov, Professor Shevilova and Professor Mans noted the insufficient theoretical elaboration of the conclusion about the relation between the legal procedure of the legal process, and therefore I think it necessary to clarify the following. Legal procedure and legal process are quite complex theoretical categories which is why we considered it necessary to approach the question of their relationship using two criteria simultaneously: degree of complexity, which allows to consider the structural aspect of the relationship, and the scope of application, a criterion to check whether the procedure is just a structural element of the process. To use of only one feature seems to us to be a simplification, which does not allow solving the theoretical question posed. As a result of using the proposed criteria, the ratio can be represented in the form of partially intersecting Euler circles. Regarding Natalia, we should agree with Andrei Vasilievich's remarks based on the presented construction of legal procedure category. Legal norms act as its legal basis, and it's really impossible to detach the legal relations from rights and obligations. As a result of using the quotation to indicate a characteristic feature that reflects the structure of the procedure, there was an indirect semantic opposition of rights and obligations and regular relations. Regarding Natalia Alexander's remarks about the division of procedural procedures on the basis of the presence of absence of a judicial authority, the author's classification of legal procedure proposed by us allows, firstly, to include all types of legal processes distinguished in science, and secondly, to systematize and examine in detail the sectoral empirical material needed to study the effect of the Internet, and the distinction between procedural procedures and judicial and non-judicial ones is really due to the presence or absence of a judicial authority. The use of this criterion seems to be reasonable, since the observance of procedural form in the judicial process is most important because litigation affects the rights and the obligations of a person, often in a more specific sense than non-judicial procedural. So, also in her review, Natalia Alexander raises the question of a unifying feature of the procedure studied. Similar questions contained in the external review of Professor Maximov. Let us clarify that the author doesn't claim to be considered in the work absolutely all legal procedures. At the same, all cited phenomena were related both to the law and were associated with information and communication technologies, as a result of which they fell into the problem field of the study. The list of legal procedures is formed from the position of their compliance with the selected features of the legal procedure as a theoretical phenomenon. The relativity of the phenomenon under investigation was verified during the course of work by identifying the presence or absence of the necessary signs that act as a kind of theoretical sieve. Professor Maximov also raises the question to the extent to which the increase in the volume of subordinate regulatory acts is due to the development of technology, and to what extent the natural course of the evolution of law. We're forced to admit that it is impossible to unequivocally answer this question and clearly distinguish between the reasons for the transformation of legal procedures. We believe that the natural course of the evolution of law is due, among other things, to the development of objects of regulation, as well as a change in objective conditions. Thus, the development of technologies can be attributed to the issues here. Turning to the sexual private issues or particular issues, the author is forced to agree with Alexei Vasilievich's remarks about the categorical assertions about the novelty of court broadcasts, noting that such a procedure has now become more widespread and more accessible. After a more detailed study, we also express our agreement with Natalia Alexandrova's remarks about the haste of assigning the Federal Treasury's obligation to place certain information in the budget process to legal procedures. Meanwhile, let us make an attempt to object to the non-allocation of legal acts on the official Internet portal of legal information as a legal procedure for publishing texts of law. We believe that in this procedure, which is an integral part of the lawmaking process, there is still a second side. There are persons who are subject to the effect of the adopted regulations, subject to the publication of an adopted law or a bylaw regulatory act in the official portal before being published in the printed source. The deadline begins for its entry into force, which directly affects persons whose rights and obligations are affected by such an act. Turning to the question of Roman Olegovich, we note that the author does not identify the concept of e-state or e-government, since the study of an electronic state as well as the definition of period of electronic government in legislation. We only cited some of the existing positions and research literature on these definitions. In addition, I would like to thank for the recommendation to further consider the stated problems in conjunction with electronic or digital law. Regarding the question of Elena Anatolievna's Voynikanis on the regulatory function of technology. In our opinion, the technology structure of code of Lessig terminology creates the conditions and directions for the legal regulation of the information and communication sphere. Creating a new virtual phenomenon, digital algorithms create at the same time a new task for a public entity, which is forced to assess the significance of the phenomenon for society, the possible risks and the expediency of regulation. Thus, the influence of the code determines the subsequent reverse process, the impact of the law and this regulation on technology. In addition, the law borrows and takes advantage of the opportunities that arise from the development of technology. As a result, the law strengthens its qualitative component and adapts to modern requirements. Turning to the question of Elena Anatolievna about the legal nature of technical norms and self-regulation procedures, let us point out that technical norms in the framework of this dissertation research were understood as rules allowing to create infrastructural and material conditions for the implementation of legal norms proper, aimed at the internet sphere. In this case, most often such technical standards were assigned to the bylaw regulatory material. In this regard, self-regulation procedures are presented to us as a separate phenomenon which cannot be reduced to technical norms. Addressing the issue of the relationship of self-regulation procedure at the micro level with legal procedures and legal norms, we note that self-regulation is not legal in the normative sense. Meanwhile, it seems possible to consider self-regulation as an unofficial law from the standpoint of communicative concept of law. An important issue is the risks associated with electronic procedures and information. Of course, in our opinion, there are currently regularly observed risks associated with excessive legislative initiatives regarding to filtering and blocking information, as well as abuses associated with a broad and arbitrary interpretation of law enforcement. In conclusion, answering the question to Elena Anatolievna, let us point out that the problem of smart contracts was considered by us as an independent legal procedure that can act as power outside the power structures, lacks any or initiative civil law procedures. Thank you very much for your attention. Thank you. So the next item on the agenda is open discussion, including statements from the floor. Well, and for any questions that we have, I am satisfied with the answers, and this testifies to the in-depth understanding of the issues. Now we have, please take your seat. Now I would like to give the floor to Maria Leonidovna Davidova, the academic supervisor of the dissertation. Research supervisor of the dissertation. Thank you very much for giving this opportunity and for giving the rights for the defendant to defend his dissertation, and my gratitude to the members of the dissertation council for very detailed review. And it took some time by the dissertation to be actually accepted for defense, and I thought that with this time it should be reworked, because this dissertation spans a decade of research, and a lot of new changes to the legal field have been introduced, and this was quite bold to approach this area from the legal point of view and the technological point of view at the same time. So, but this is a big plus for the defendant that he combined expertise in law and information science. This is and also manifested research skills. I think in combination, this combination is evident in this research work. Thank you very much. And I hope that this dissertation will be regarded as worthy for the third degree. And now I would like to switch off the broadcast because we're going to discuss our verdict, and members of the audience who are not part of the dissertation council may ask you to leave the room, and in 5 minutes you will be invited to come in again. Please, members, only members of the dissertation council can stay in the hall. Of the audience to return to the hall. So we were very brief. It didn't take us 5 minutes. Please, broadcast should be should be switched on. Yes, the broadcast is on now. So I would like to put the question to the vote on conferring a degree of legal, a candidate of legal science on Makarov Vladislav Olegovich. The positive decision is valid if 2/3 of the Dissertation Council members vote in favor. Professor Shevelova, I support the decision to award the degree to Makarov Vladislav Olegovich, Romashov, Roman Anatolovich. I am in favor of awarding the degree of the candidate of legal science to Vladislav Olegovich Makarov. Professor Venikanis, I am in favor of conferring the degree. And member of the council Vasilevich Grigor, I am in favor of conferring the degree of candidate of science, and my opinion as the chairman of the Dissertation Council, I am also in favor of conferring the degree on Makarov Vladislav Ilyich. Out of the 5 members of the Dissertation Council, all 5 members voted in favor of the resolution to confer the degree, and therefore the decision to confer the degree of candidate of legal science in the specialism in the degree field 120001 theory and history of law and state, history of legal teachings about the state, on the topic transformation of legal procedures under the influence of the internet is taken. Dear members of the Dissertation Council, I am greatly grateful to you for a very close examination of my dissertation and for the decision that you've reached. And my special thank you to my research supervisor, Professor Davidova, Marina Leonidovna, and I'd also thank Sergei Alexandrovich Belov, who organized this Dissertation Council, Vladislav Arkhipov, Professor Arkhipov, for his recommendations. Would like to thank my wife, my friends, and colleagues who supported me in writing this dissertation. On behalf of the Dissertation Council, I congratulate you on the defense of your wife, of your research supervisor, and thank you, thank members of the Dissertation Council and everybody who supported this session. The session is officially closed. The broadcast must be switched.